So what happens in California when you are arrested? At some point, the officer will tell you that you're under arrest, generally put you in handcuffs, and take you in his car to a police or sheriff's station. At that point, you should be given Miranda rights, where it is explained to you that you have the right to remain silent, you have the right to an attorney, and several other rights, and that anything you say can and will be used against you. Once you get to the sheriff's department, they generally book you, which includes taking your fingerprints, taking a picture, and processing the paperwork against you. At that point, you're either bailed out by a family member or friend, or you can be released on your own recognizance. Otherwise, you're going to wait in jail until your criminal arraignment, which is generally within 72 hours. We have a lot of clients who call wondering how bail has changed. Bail in the state of California is no longer set on a set schedule, but instead on an individual process where they assess your risk and the risk of you not showing up to court or committing another crime while you're out on bail. Also, there is, with the same assessment, you might be released on your own recognizance. And lately, due to overcrowding, oftentimes they will let you out anyways because they just don't have the room and you are the least risk of problem. When people are charged with a crime in the state of California, they're very concerned and want to know what will happen at the first court appearance. The first court appearance is called an arraignment. At the arraignment, the judge asks, how do you plead guilty or not guilty? You should always enter pleas of not guilty, at which point you or your attorney receive the police report, have explained to you the charges against you, and the case is then set for another court date. It's more of a technical hearing where you declare that you are not guilty and that you want to fight the case. In a criminal case in California, after the first court appearance or arraignment, the case is generally set for a pretrial conference. At the pretrial conference, which is another court appearance, that's where your attorney has the opportunity to meet with the district attorney, sometimes even the judge, to negotiate your case and to explain defenses and see if the facts of the case warrant a dismissal, a reduction in charges, or how the case will be handled prior to trial. If you're charged with a felony in the state of California, you are entitled to a preliminary hearing. At the preliminary hearing, the district attorney's office has to present evidence to show that there's enough evidence of a crime that it warrants proceeding with the case against you and proceeding to trial. So it's like a small trial where they present certain evidence against you and see if it offends justice to continue with your trial. Most of the preliminary hearings, afterwards, the judge finds that there is enough evidence, and the court will then set the case for another arraignment where it will proceed to the trial phase. In the state of California, all criminal defendants are entitled to a copy of their discovery. What is discovery? Discovery is basically the police report and any evidence that the district attorney has that whether they're going to use it or not, any evidence that they have against you on your case. The district attorney is required to give you all evidence on your case. The most important part of your criminal trial will be the opportunity that your attorney has to plea bargain on your behalf. This is an opportunity for your attorney to meet with the DA to go over the defenses, to go over the evidence. If the facts of the case require, that can lead to a dismissal, oftentimes for the charges to be reduced, sometimes from a felony to a misdemeanor, sometimes from a serious charge to a less serious charge. In other cases, it's a matter of negotiating away the penalties on the case. It is very important that you hire a competent and experienced attorney who has not only experience in criminal cases, but has experience with this DA on cases just like yours. Their ability to plea bargain on your behalf is far greater. They know the DA and they know where the DA's limits are and will get you the best result. In the state of California, you have many rights in a criminal trial. These rights include the right to remain silent, the right to a jury to decide the facts and the guilt of your case, the right to cross-examine witnesses, the right to present witnesses, the right to have an attorney, and the right to present defenses on your behalf. Make sure you have a good attorney who understands your rights and is willing to fight for your rights in your criminal trial. Many clients want to know how long it's going to take for their criminal case to be finished. Most criminal cases take several months, oftentimes because of court schedules, because of the complexity of your case, but mostly because your attorney, a good qualified criminal attorney, will need several court appearances in order to negotiate on your behalf to try and work towards a dismissal, a reduction in charges, or any other sort of a plea deal that can end the case in your favor.